caution, we wanted to bring it to the court's attention now and ask for leave to amend the pleading. I know the court is well aware of of Rule 63 and 66, so I won't spend any time on that, other than typically under a normal situation, we would be able to amend our pleadings freely even through today.
Did you guys want this on the record? I apologize. We haven't gone on the record, and so is this something that needs to be on the record?
Sure, Your Honor.
All right, let's go on the record. Ms. Pettit, if you could now the cause number and case name.
Sure. The case is Holm and 5 Points Holdings versus 5 Star Global et al. Case number is DC 20-08643.
Okay.
May I proceed, Your Honor?
You may.
Okay. As I mentioned, we are seeking to amend or clarify our pleading as to Southfield only. So this doesn't have anything to do with Mr. Tillotson's client, just Ms. Isha's client. As you know, our claim against Southfield is breach of fiduciary duty. And what we are seeking to amend is just to clarify that it is breach of fiduciary duty or knowing participation in breach of fiduciary duty. As far as our claim goes, under normal rules, we would be allowed to amend even through today. There was a scheduling order in this case. I will add that it has not been complied with strictly, I don't think, by any party, but there is one in order in place, which is why I'm seeking leave to do this amendment. I know the court is aware that allowing the amendment is mandatory unless the amendment is a new substantive matter that reshapes a cause of action or the trial, which we do not believe it does at all in this case. Citing just briefly to the Texas Supreme Court opinion, it's settled as a law of the state that where a third party knowingly participates in the breach of fiduciary duty, such third party becomes a joint tortfeasor with the fiduciary and is liable as such. So we're wanting to clarify that we believe Southfield either actually breached their duty on their own or knowingly participated in the other defendant's breach. So breach of fiduciary duty has been pled during this case against every defendant. So there's no new claim that these other parties breached a fiduciary duty. Those have been pled from the beginning. One other case I just wanted to cite too, that knowing participation in a breach of fiduciary duty is a derivative claim requiring an underlying breach of fiduciary duty in which the defendant knowingly participates. So this is simply a derivative claim of what we already have. Our allegations of breach are the exact same. There are no new allegations. It's the new theory, same theory. There's no new facts. The issue still, Your Honor, is that of control. So our claim from the beginning has been that Southfield controlled Caledon and their executives and breaching fiduciary duties.
Ms. Pettit, why did you guys wait to plead this?
So I think it kind of came up just in drafting the jury charge is kind of when it appeared to me that, well, actually it's the only issue is control. It's just a matter of degree. Was it actual control or was it participation with the others? I think that it's been argued in front of this court in the summary judgment briefing, which I will show you. It's just one of those things sometimes, as you know, as a case goes on and the facts kind of fall into line. I mean, obviously we could have even moved to amend during trial to allege this, but I just kind of think the particular facts as they have come out would either be that Southfield actually controlled them or that they participated with the management when the management breached their fiduciary duties. But there have been claims of breach of fiduciary duty against all parties throughout the extent of the case. So, like I said, the issue is still control. It's the exact same facts. Either they did it themselves with their own hands or they sat there while Caledon did it with their hands. It's just an issue of degree. And so in looking at the jury charge, like I said, it kind of at that point is what triggered it. We don't believe there's any prejudice here. There's no new facts for Southfield to discover. Any way you look at this particular issue, the issue is still control. They've been at every deposition. They've received every document. They have, been involved. And so I don't think there's anything that they could have asked that they wouldn't, that they would have asked, but they didn't already ask or participate in by way of the depositions. So again, the alleged breaches against each party have been bullet pointed in our pleading from the very beginning. So there's no new breaches that we're actually alleging. And there's no surprise I put a little snippet from our summary judgment response. As you recall, we argued control in front of you for a very extended hearing and quite a bit of briefing on this particular issue. So just one snippet from our responses: Southfield consulted on and approved every significant and not so significant management decision relating to 5-Star Global. So this issue of control has been front and center the entire time. There's no new facts that would exist that they haven't already participated in the discovery on. So we ask Your Honor to allow us to amend to clarify that it's either breach or knowing participation, and breach its derivative claim. Thank you, Your Honor.
Response?
Good morning, Your Honor. So if you don't, can I share my screen real quick, Your Honor?
Sure.
Can you see my screen, Your Honor?
Okay.
All right, Your Honor, plaintiffs are asking you to allow them to bring a substantively new cause of action 2 weeks before trial, actually 1 week now. So plaintiffs have always alleged that Southfield breached their fiduciary duty. We have developed our case. We have taken discovery based off of that allegation, that our conduct in some way was a breach of fiduciary duty. We have not focused on plaintiffs' allegations against the other defendants. They weren't pertinent to us. What the defendants did or did not do to breach an alleged fiduciary duty to plaintiffs, or FSG in this case, was not relevant to us. But now plaintiffs want to change the entire card deck. They want to turn everything around on us and say, hey, you're not just liable if you breached an alleged fiduciary duty that you owed, you're also liable if you knew about something that the defendants were doing that breached their fiduciary duties and you participated in it in some way. Now, plaintiffs' amended petition recognizes that this is a new cause of action. Plaintiffs have added a claim here, and they recognize that under this new claim, they're going to have to prove the existence of a fiduciary duty by a third party. Some third party owed a fiduciary duty that we knew about the third party, about the third party's fiduciary duty, and that we participated in some conduct that constituted a breach.
Ms. East, can I ask a question? Because I should recall this and I don't. So there was a trial involving Delgado previously. I think you're aware of that. Yes. Did you guys, I don't remember, were you at the trial or not?
We were not, and we only just recently received the trial transcript. We did not get to ask Delgado about any of his conduct during that trial. We did not get to, and we did not even ask Mr. Lay and Mr. Baggett, the other defendants that they mentioned here. We didn't ask them anything during their deposition because we weren't concerned with their alleged breaching conduct. It wasn't the same. What mattered is what we did and how we.
So I can only see this little part of the screen. I don't. Lay and Baggett, are they on? I only see Delgado listed. Is there something about Lay and Baggett?
The other defendants that they're referring to would include Mr. Drew Baggett and Mr. David Lay.
Oh, the other defendants in this case. Okay, that makes sense. Mm-hmm. That makes sense. Okay.
Yes. I believe that's who they're referring to, Your Honor, but there have been no factual allegations added to this petition that would let us know that. So, Your Honor, to prepare to defend this claim, we're going to need to talk to plaintiffs again. We're going to need to find out specifically how plaintiffs allege, or who plaintiffs allege we assisted. Who did we assist? What do they allege we assisted them to do? And how were we supposed to know that what they're alleging constituted a breach of fiduciary duty? We didn't ask them any of those questions. We didn't ask Mr. Drew, Mr. Baggett, or Mr. Lay, or Mr. Delgado any of these questions. We weren't involved in the Delgado trial, and we certainly would have been had we known that this was going to be a.
Now, remind me again, I know Mr. Tillotson, you weren't involved in the case back then. Was there an agreement reached? Remind me of the history, maybe Ms. Pettit can remember this. why did we have Delgado as a separate trial? Was that an agreement between why was that a separate trial?
It was because Mr. Tillotson's client wanted it to be separate and opposed the consolidation.
Okay. And Ms. Ish, if you had known that Delgado, they were going to make this assertion, would you have requested a consolidation or wanted to participate in the Delgado trial, or what would you?
Certainly wanted to be involved in the Delgado trial. Another complicating circumstance here, Your Honor, is because Delgado is not a named defendant in this case, and he's in South Carolina, I believe, we don't even have subpoena power over him. We're not going to get a chance to ask him any of these questions. Well, certainly not with, a week before trial. We could figure out how to subpoena him over if we have the time we need to get, process.
Ms. Pettit, I do have a significant concern here about trying to bring Delgado into this case, and especially since Southfield wasn't involved in the other case, it does seem to really reshape the case as to Southfield, at least as to the claims involving Delgado.
So, Your Honor, I guess I would say that I agree that the Delgado ones are a tiny bit different, other than the fact that Delgado was acting as the CEO of the defendant, Five Star Global. Also, I'm sure Ms. East can correct me if I'm wrong, but I'm pretty sure Ms. East's client participated in the mediation in the Delgado trial, and also, I believe, opposed the consolidation. I think the significant part that I want to point out is that Ms. East just said that there were no factual contentions added to our proposed petition, which is my exact point. There is no additional fact. Our claims all along, Your Honor, have been that Southfield breached through the other defendants' actions. We've never said that they came in and were making the actual day-to-day decisions in person at the office. Our claims have always been that their breaches occurred through the other defendants' actions. So they did, Your Honor, have every reason and every deposition to ask the defendants about their breach, because that's been our claim all along. There are no additional factual allegations.
So, Your Honor, may I respond to that?
Sure.
The only cause of action that has ever existed against Southfield was a breach of fiduciary duty that Southfield allegedly conducted. It was a breach of fiduciary duty against Southfield, not Southfield participating in somebody else's conduct. It was our conduct that was at issue. Now you're going to want to throw in questions of
So let me ask this, and I don't know if it should come from the 8th Amendment or amended or 7th Amendment petition, but can you show me the original claim against Southfield so I can compare them?
Yes. The original claim against Southfield was here.
Is that this?
Yes.
So is this the original claim here, Ms. Ish?
I believe so. Yes, Your Honor.
Yeah, those bullet points haven't changed. So they're in the 7th or the 8th. The only thing that's added in the 8th is the paragraph below that Ms. Ish had highlighted a moment ago. But these 5 bullet points are the same ones asserted against all defendants from the beginning.
So there hasn't been an independent client. I mean, there wasn't a section just against Southfield. It's apparently just in this portion where it's
correct, Your Honor.
Where they've come in. So I'm going to treat these differently. For Delgado, if we're really going to go into the issue of Delgado, I think that opens a huge can of worms here, Ms. Bennett. And so if you really want to pursue this as to Delgado, we would probably have to bump the trial setting unless Mr. Tillotson has a big problem with that, which I doubt he will, and then allow them to conduct discovery on that issue. The other issue I think is a little closer. But as to Delgado, that I can see how Ms. Ish, looking at this, would not participate. I mean, they didn't even participate in the Delgado trial. I can see why they would if they had known about this, these other claims, because Mr. Delgado is not a defendant in this case, or never has been, right?
That's correct, Your Honor. And based on that, I will waive our request to loop Mr. Delgado in with this motion for leave and just ask that it be as to the named defendants in this case number.
Your Honor,
Okay, so let's talk about that, because I think that makes this is a lot closer case. So what would you have done differently, assuming that Delgado's out of this? What would you have done differently if you had known about this new claim, Ms. Ish?
So, Your Honor, we would have deposed Holman Harrison, and specifically, Holman Harrison are pretty much the representatives of plaintiffs in this case. We would have specifically asked them, and we did not ask them any of this. We would have said, Mr. Holm, what other defendants in this case do you allege that we assisted in breaching fiduciary duties? Number two, how did we do that? And number three, why were we supposed to know that they owed you any fiduciary duties from the beginning? We don't know, for instance, we don't know if Mr. Holmes' allegation is that we participated in the action by merely just sitting back and letting it happen, just because we didn't respond to emails, or because we actually took action. We don't know the scope of Mr. Holmes' allegations, and it's not fair to force us to learn those allegations for the first time in front of a jury. Once we figured out the scope of the claim, we would have actually deposed Mr. Baggett, Mr. Lay, Mr. Delgado about these issues. And, Your Honor, specifically what we knew about what was going on in these alleged breaches of fiduciary duties and the extent of our participation, if any. We would have moved for summary judgment on that, so we would know the scope of plaintiff's claims and we could have challenged plaintiff's cause of action. We would have done all of that during the discovery period. And, I think a perfect example, Your Honor, is this one. They're alleging their new allegation would have us liable for failing to properly operate for knowing about failures of the FSG defendants in operating the company. We need to know from Mr. Holm what did we do, what did the FSG defendants do in failing to properly operate the company? We know what they alleged we did because we asked them those questions. But what about the other defendants? What did they fail to do to properly operate that company?
Wouldn't the defendants, this is why I separated Delgado and the other defendants, wouldn't the other defendants have asked about this? Wouldn't they have every incentive to ask about this?
Well, the other defendants would have, but they certainly would not have discussed what we knew about it. And we certainly would not have, just because the FSG defendants allegedly failed to properly operate the company doesn't mean that we are alleged to have engaged in that same conduct or to have known about that conduct, Your Honor. And I also want to highlight something for Your Honor. It is going to be almost impossible to separate out Delgado's alleged breaches of fiduciary duty from the other FSG defendants. And the reason that is because Delgado and Drew Baggett and David Lay, the other FSG defendants.
Ms. East, you can't have it both ways. If you guys didn't oppose this was the issue all along with Delgado that I kind of raised, but you guys fought, is that you guys wanted a different trial for Delgado. I still don't know why, but there was a push. And I know if Mr. Tillotson was on this case at the time, I don't know that he would have taken the same position, but having Delgado trial as a different trial is something that you could have fought a long time ago.
Now, Your Honor, I don't know that we did fight the consolidation. I'm not sure that we did, number one. And number two, had we known that they were going to bring this claim, we almost certainly would not have fought the consolidation. We would have wanted to know and to try all of this stuff together so we would know what Delgado.
Well, we're not letting them go. I'm definitely not allowing them to go into the issues with Delgado, because I completely agree with you that that's very problematic, and Ms. Pettit has dropped that claim at this point. And so that's now, again, a much closer call because it's just the other defendants. They had every incentive to participate in this case, and and you had every incentive to participate in the case. You guys were all in the case together. So bringing up Delgado, I think, is not something I'm going to allow at this point. So just talk about why the other defendants, because we're not going to have Delgado in this case.
Your Honor, may I respond briefly just with respect to this paragraph 140 that's up? So as you pointed out, these have been all grouped together the entire time. So the Southfield defendants, of course, have conducted discovery on all of these, and the claim is the same. We've alleged that Southfield actually controlled Caledon or the principals doing each one of these things. So they've been in every single deposition with respect to these 5 bullet points, and they have had to take discovery on that because the allegation is simply a difference in one of degree. Did they actually control it, or did they watch Caledon do it? Either way, they had every incentive to make sure that they were able to prove then and now that Southfield wasn't a part of it. It's no different. And so I know there's some benefit to Southfield and trying to make this a complicated issue, but it's actually very simple. And it's simply a derivative claim.
Mr. Tillotson, did you want to say anything at this point?
No, Your Honor. No. I mean, obviously I support the Southfield position, but I don't really have anything to add.
Your Honor, abuse control is not participation. It simply is not the same thing. Our actions, again, are what evidence control. Our actions as far as participation also don't show our scienter in knowledge. We didn't get to ask any of the other defendants or Mr. Holm or Mr. Harrison how any of our actions rise to the level of the knowing scienter participation that is required to prove these claims.
The only other thing
sorry, go ahead.
I'm sorry, I didn't mean to cut you off, Ms. East. The only other thing I would add, Your Honor, is I'm pretty sure there's a joint defense agreement between the defendants as well. I'm not 100% sure, but I'm pretty sure there is. So there's been every incentive all along for both parties to escape liability on each claim as to each defendant.
And one other thing I highlight, Your Honor, is, if there's been every incentive to do this, why couldn't plaintiffs just let us know what their claim was? Why couldn't you put us on notice so that we could develop a proper defense to a knowing participation claim? There are numerous cases out there where the court has simply said, look, you waited way too late to do this, and you admit you knew about it long ago. There's no reason you could not have brought this earlier. It's simply not fair. It doesn't comply with our due process to add a claim with substantively new elements on the eve of trial.
I guess I'm trying to figure out how the discovery would have been different. It's hard to kind of see in this case, but I guess you never really had a chance to know. The only area where I have concern, I guess, is that Southfield never had an opportunity to ask the plaintiffs, what do you claim that we knew about the other defendants' breach of fiduciary duty? They wouldn't have had that incentive because that wasn't a claim at the time. I guess that's where I do have a concern.
Your Honor, may I respond to that?
Yeah.
First, I think that based on when I put the summary judgment response up on the screen, it's been clear that I think the defendants have been on notice of this for quite some time, because even in our summary judgment response, we're saying that it was through Caledon that this all happened. That has been argued over and over. I don't think the other thing I would say is that the knowledge is proven by Southfield's documents. This isn't something that we're independently going to have. All of the allegations show that these things happened behind closed doors between the Caledon individuals and Southfield. It wasn't something that plaintiff participated in. That was our whole problem. So the information that they need, I can tell you Mr. Holmes' testimony is not going to be any different. If we want to do a limited deposition on those topics, that's fine. We can do it this week, but the testimony is not going to be any different, because what happened was done behind closed doors between Caledon and Southfield. It's not anything that our clients were privy to, which is our whole argument in this case.
Your Honor, can I respond?
Yeah.
The fact that Ms. Pettit is admitting that even back at the dispositive motion phase, we were dealing with the questions of, she knew about this alleged claim and chose not to bring it, is in and of itself just unacceptable. You don't get to bring this claim this late, especially after we've already done all of our exhibit compilation, our deposition designations, our jury charge. We have done all of that based off of the current claims. And now, a week before trial, you want us to amend all of that while preparing our witnesses and taking a new deposition? That's highly prejudicial. I would also say, Your Honor, dispositive motions came after the discovery deadline in this case. So we had no reason, even if we did learn about this cause of action from her dispositive motion response, we still would not have had the discovery that we needed to prove the claim because we had defend the claim because we had no reason to take it.
Your Honor, just to be clear, we didn't know of the claim. We knew of the facts. Everyone has been arguing the facts that fit within this claim the whole time. It's not like we knew of some claim and sat on it. We knew of the facts. We still have no new facts. But
You still have no what?
we have no new facts. It's the exact same facts.
no new
that we've been
facts, it is
alleging
no
all
defense.
along. So we
Okay.
didn't sit on some facts and not disclose it and try and throw it on them. These have been the same facts that have been argued over and over and over in summary judgment practice, to Your Honor. There's nothing new. I'll say one more thing and then I'll try to stop. It's just a derivative claim. It's no different than what's been alleged.
But again, it has different elements, Your Honor, entirely different elements that we need to have the chance to be able to defend against. And we should have had notice of. It's not fair for us to find out for the first time at trial what plaintiffs are truly alleging tied to these new elements of a brand new claim.
All right, I'm gonna probably make a decision that neither side's gonna like. I'm gonna allow this amendment but only as to the claims involving the other defendants, not involving Mr. Delgado. If either defendant would like to move the trial setting, we'll put it on the next date that we don't have another special setting. And this would also give Mr. Tillotson an opportunity to have a little more time to get a decision out of the Court of Appeals. Ms. Pettit, if you don't want that, then you would have to drop the claim.
May I confer with my client and then send an email to the court and counsel with respect to that?
And I will tell you,
I just don't know that I have client authority to move something without their permission. So I would need to double check that with my client with Your Honor's permission. But I can call them now and come back on the line if that's easier.
I'm sorry, Mr. Tillotson, what did you say?
So that's fine with me. I mean, we're going to file our motion to stay regardless, just out of precaution. But if she agrees to move the trial date, we'll apprise the Court of Appeals of the new date.
Does Your Honor know the next available date so that we're at least aware of what that would be?
And let me just caution you guys, you're living in post-COVID or whatever era we're in right now. Times, I'm not saying COVID is over, but that unfortunately that our dockets are horrible right now. If we do move it into a date that there's another special setting, there may be special settings from the week before that may take out this case. That's the other thing I would urge you guys to caution for. Because, go ahead.
I just wanted to raise Mr. Harper's on the line, and he will be trying this case with me. I know he has some competing settings in April. So I just wanted to give him the chance.
I know Mr. Harper, I like Mr. Harper, but his schedule has no impact on my schedule.
Gotcha. Okay,
Sorry.
sounds good.
There you go, Mr.
Counsel.
There you
My
go,
feelings
Mr.
are not
Harper.
hurt, Your Honor.
No offense to Mr. Harper, it's just, he's not lead counsel. We only take into account lead counsel. I'm sorry, this is taking a while.
While that's coming up, Your Honor, so that I have the full picture, if the trial date is bumped, would you also be reopening discovery, or we're just moving the trial?
So, that's a good point. So what I would allow to occur, I would allow her to retake Mr. Holmes and Mr. Harrison's deposition on the limited issue of what they claim Southfield knew about the breach of fiduciary duty. And then I would also allow them the opportunity to send, I'd say probably 3 requests for production and maybe an interrogatory or 2 on that same topic. And you'd have to answer that within 14 days. So just so you kind of have a feel.
Understood, Your Honor.
So the next date we have without a special setting is April 19th. We do have a special setting the week before that. Let me see what case that is.
That's PCB, but that's going to get moved.
That's Clark Ridge Canyon. I don't know if any of you guys are familiar with that case, but Mr. Arnett, Mr. Gobert, and Mr. Hayes are all on that case, and it's especially set the week before. I don't know how long that case will take to try, but it wouldn't surprise me if it was 2 weeks. It's a commercial case.
Certainly sounds like a fun group, Your Honor.
It is. It is. It's a good group. Good lawyers, all of them are good
That'll be
lawyers.
fun. That'll be fun.
And then we have a special setting on the 26th. We get a little more open. May 10th would not be a bad date. It's a couple weeks away from a special setting, and we only have 13 cases set that week, so we've had quite a few settlements that week. So May would not be a horrible time to do this if we wanted to do it.
Okay. May I call my client quickly, Your Honor?
And Mr. Tillotson, Ms. East, your schedules do matter to me. Does May work for you guys?
May 10th would work, Your Honor.
Okay.
May 10th would be fine. May 10th. April 19th is my birthday. I don't mind getting birthday wishes. I would prefer not to pick a jury, but that said, May 10th is fine with me.
I think April 19th is very risky, just to be honest, given the schedule. So
All right.
you're
Yeah,
better
we
off.
can make May
May
10th
I
work.
call my client quickly?
Yeah, go ahead.
I think if we do May 10th, we'll certainly know from the Court of Appeals something.
It also means you'll get to see me because
Yeah.
my
Well, that's really the most important thing. So,
or I get more free time one way or the other. But I've got Judge Reed O'Connor out in Fort Worth has grabbed me starting April 18th. So
That won't last more than 2 days.
well, I don't know for sure how long it'll last, but I'm 100% sure he's not going to continue it barring a lightning strike on himself.
He did a major criminal case approximately a month ago. 45 witnesses were called. He gave each side 15 hours and each side 10 minutes for openings.
oh my God.
Criminal.
Wow.
4 counts. No, 10 counts. 10 counts, 4 defendants. Each defendant got 3 hours and 45 minutes.
Yep.
Yikes.
One of our associates had just joined the U.S. Attorney's office and was prosecuting that. She said it was absolutely. But that just goes to show. I shouldn't say this out loud with the judge here. It just goes to show you what the court gives you. You can make it work. We all scream at it, but the answer is we made it work.
Well, as guilty verdicts across the way, the defendants feel differently. But,
Yeah. It didn't work with the defendants that time.
I was surprised, Your Honor. The standard in the Fifth Circuit for time limits is very difficult. You have to show exculpatory evidence was unable to be put on. And the first
Wow.
question you get from Justice Jones, Judge Jones, is, well, if you had exculpatory evidence, why didn't you put it on? What else were you doing with your time?
Well, I very rarely do time limits, except for occasionally in bench trials, but almost never in jury trials.
Well, I think Fort Worth is the only place in the Northern District of Texas that they will put time limits on criminal trials. I mean, it's
Yeah, that's
pretty crazy.
surprising to me.
I've never heard of that before. That's the first time I ever heard of it was through Judge O'Connor.
McBride started it, and then O'Connor adopted it after he moved over to Fort Worth.
Is he the only judge in Fort Worth right now? Or is there a second judge now?
They've got Judge Pittman out there, and I'm not sure if Means is still on senior status, but I think he might still be. I don't know, Jeff.
He is. Means is still in senior status. He's not taking anything complicated or lengthy, but you've got now two judges, Pittman and O'Connor, and they've got a bankruptcy judge, Lee Morris. Your Honor may know him. He used to be at Munchart.
Okay.
He's now the bankruptcy judge out there. So
I have a couple pretty extensive hearings that I need to get to.
I think she could just email Your Honor. If they agree, then it's easy. If not, then we'll go this
Well,
way.
I'd rather get this taken care of. So let's talk. We just got an email on this Mabonta case, and I'm not sure what it meant. So are the attorneys here on the Mabonta case?
Yes, Judge. I
Yes,
saw
Your
Mr. Herring. Yep, there he is.
Yeah, I just got an extensive email, and kind of give me an idea of what's going on here.
We have two motions that are unopposed and one opposed motion, which is a motion for sanctions and asking for some defenses and counterclaims to be struck. So that'll be lengthy. We think we're going to be in your courtroom with bells on tomorrow morning, but we have a couple of housekeeping questions around that maybe we could deal with real quickly.
Sure.
One is that I've subpoenaed some witnesses. It would be fine with them because they all have jobs, appearing by Zoom to be sworn in, and then they'll be on call later in the week. So I wanted to ask you if we could do that. I think Mr. Herring and I have agreed on that.
That's no problem with me.
Okay. And the other is how much time we have for trial. We know there were 3 people ahead of us that didn't look like they were lengthy trials. But this is a fraud case. It does have a lot of documents. And so that was my second question.
And Your Honor, I have several questions too, but I think this is a 4 or 5 day trial, at least.
At least.
At least. The other issue I have, though, Your Honor, is that the agreed motion we filed is a 76A motion.
Mm-hmm.
All the documents in this case have personal health care information. Not all of them, but the great majority of them. We're going to have personal health care information, list of names of patients, treatments of her patients, et cetera. So when we were making our exhibit list when I was getting it ready about 10 days ago, I said, what are we going to do about all this? Is a lot of redactions if we're going to have to redact all this. And Nicole and I called her and we talked about this. And they said, let's file a 76A motion. The problem is we did file that motion, the agreed motion, but we haven't really complied with 76A because we haven't given 2 weeks notice of the hearing. We gave a week's notice of the hearing. It's only been on file with the Supreme Court. I don't know if it's been on file with the Supreme Court at all. We tried to get it on file with the Supreme Court, but we're going to have a big issue on that, I think. And I'm a little worried about going to trial with all these exhibits out there that are going to have all this personal health care information in it without having a true 76A order, not some stopgap order, but a true 76A order in place.
We know that the court has authority to issue a temporary sealing order while we wait out that time if the court deems that would be appropriate. I've done that in a case out of Collin County where we had an emergent issue. Somebody filed something we had to get off the docket, and was willing to give us a temporary